दर्शकों, स्वागत है आपके अपने चैनल कानूनी चर्चा पे। एक यूट्यूब चैनल है, जैसे मैंने पहले भी बताया है। वेलकम व्यूअर्स ऑन योर ओन चैनल कानूनी चर्चा। जैसे आपको जानकारी है कि हम लॉ सीरीज पे बात करते हैं और डिफरेंट वीडियोस, डिफरेंट लेजिस्लेशन, पार्लियामेंट टेक्स्ट पे बात की। और पिछले दिनों मैंने हिंदू मैरिज एक्ट की लॉ सीरीज शुरू की हुई है। इसकी डिफरेंट सेक्शन पे बात की और हम सेक्शन 15 कंप्लीट कर लिया और 16 पे पहुंचे हैं। इन बिटवीन मैरिज रिलेटेड जो मैटर थे, तो कुछ व्यूअर्स और कुछ जो स्टूडेंट्स, लॉ स्टूडेंट्स थे और कुछ लॉयर्स ने डिमांड रखी कि आप लिव इन रिलेशन, जो मैरिज आज जो हमारा समाज बदल रहा है, सोसाइटल मोरलिटी बदल रही है, जो कपल्स लिव इन रिलेशन में हैं उनके राइट्स, उनको क्या है, कैसे वो लिव इन रिलेशन में रह सकते हैं, सो दैट दे शुड बी सिक्योर अंडर लॉ आल्सो। चैप्टर 20 deals with the marriages related offenses. This is chapter 20 of Indian Penal Code. We will find one of this violation offense is of bigamy under section 494 IPC and 495 IPC. There are this is related to bigamy. Now let me read out the section. This 494 related to bigamy. This is marrying again during lifetime of husband or wife. This section is also applicable to both husband and wife. If either of them solemnize second marriage, enter into in a relationship which is called or otherwise considered as bigamous, or enter into bigamy, then let us me read out. Whoever having a husband or wife, then it is a gender neutral section. Living marriage in any case in which such marriage is void. This is similar situated with the word void as was available in section 17 of Hindu Marriage Act. So first, the second marriage must be a void under law. Among Hindu, the second marriage under section 11 and 12 are void, nullities, and voidable can be declared nullity by a court of law under section 11 and 12. So section 17 is applicable when there is a bigamy, and the bigamy is made punishable under Indian Penal Code. Similar word is available in if the second marriage is void, then by reason of its taking place during the life of such a husband or wife shall be punished with imprisonment of either discretion for a term which may extend to 7 years and shall also be liable to fine. This is very clear. Its wording is very clear. If in subsistence of the first marriage, if any of the couple, any of among the couple, between the couple, any one of the couple, this male or female, any one out of the couple, you may say, oh, then if he solemnized the second marriage, then they are liable under section 494. I have already said that offense is punishable for with imprisonment of 7 years. There is a fine also. And now I have already told you that a Muslim cannot be held liable for second marriage, because under his marriage is regulated by the personal law applicable to the Muslim marriage. So they as per Sharia, they can perform 4 marriages at a time, a male Muslim. So, but I have already said that a female cannot have more than one marriage. So, under this section, this now primary question, important question is the second marriage should be void in eyes of law. How a marriage is a void, that I have said under Hindu Marriage Act. It is void if it is violative of section 5 and it can be declared as nullity under section 11 and voidable under section 12. Now a practice has started in India, particularly in among Hindu community, Hindu couples. The male or female, this is gender neutral section I have referred, in order to avoid the punishment as provided under section 494 of Indian Penal Code and under section 495 of Indian Penal Code for entering into bigamous relationship. They started solemnizing second marriage by converting into Islamic faith, but which has found after going to the facts of the cases, but they all marriages have been solemnized in order to absolve from the criminal liability under Indian Penal Code. I have referred the section particular 494 and 495 RPC. After convention, but this NGO, a society, Kalyani, its president approached the Supreme Court. Earlier, petitioner they had their own. Most of the petitioners were female, the first wives who have suffered, who were aggrieved by solemnization of second marriages by their husband by adopting Islamic faith, only with the intention to solemnize the second marriage. They were not propagating or otherwise adopting the Islamic practices. Their main consideration was to solemnize second marriage and get absolved from the criminal liability. This is what has found and what the petitioner has held Supreme Court to main Sarla Mudgal case, and Kalyani was this a society, and its president has approached the Supreme Court, and the Supreme Court of India, in I think it is a judgment of 1995, has held that that conversion, if made by anybody, that if it is only with the intention to solemnize second marriage, so then that marriage is considered as void in eyes of law, because in existence of the first wife, in subsistence of the earlier marital relations with the earlier wife, then first wife, then on this ground their marriages, second marriages, in under this Mudgal Sarla case, Sarla Mudgal case versus Union of India. It is a case of 1995, I think. Then their marriage was 1995, I think. This 1995 Supreme Court 1537. I have prepared the papers and made an exercise in order to, and in my brief speaks that it was a case before Supreme Court, Sarla Mudgal versus Union of India. It was decided in, it is, you will find this in this judgment in AIR 1995 Supreme Court of India, 1531 page been out. Now simultaneously courts have held that they are liable to be dealt with under section 4954 and 495 if the wife is knowing. Earlier wife is there in both the cases, but if the fact of earlier marriage has been concealed by the accused, the accused, who enter into a second marriage, then if he has concealed this fact from the second wife, then he is liable. This is what about this Sarla Mudgal case. Now, in Sarla Mudgal case, one thing they have said that this practice of conversion is not they have not recognized it. They have deprecated it. And simultaneously they have said that it is a discriminatory against the male and female of the Muslim couples. If a female cannot enter into a second marriage, but male can enter into second marriage, so he is not liable for the commission of offence under section 494 of IPC. But if a wife, female wife or female of Muslim faith solemnize second marriage, she is liable. She can't solemnize the second marriage. So similar. Though in order to avoid this, now question is how the second marriage is to be proved in the complaint case before the magistrate. Obviously, section 5 provides for the conditions of the marriage. Section 7 deals with the ceremonies of the marriage. Or in under criminal law, if somebody is to be punished, obviously he has to undergo the criminal trial. Then beyond reasonable doubt, the proof is of second marriage must be there. Obviously, second marriage to be proved if the ceremony of the marriage is sapatati. This is among Hindus, most of Hindus. The 7 steps around this holy fire is to be performed. Then the complainant, obviously, she may be a wife or husband as per this section 494 or section 70 of the Hindu Marriage Act. Then the second performance of the second marriage should be proved beyond a reasonable doubt. Or it is to be proved simultaneously that second marriage is void. Now there is what are the rights of second marriage? So second marriage is a nullity in the eyes of law, or law courts have decided that this marriage has not been recognized either by this family courts or as the second wife has no civil rights. Because her marriage is null. So I say here that during solemnization of marriage, the party should be cautious. They must see back, explore about whether any of the parties have earlier their partner. If it is a wife, if so, then as per section 5, the two adults can enter into marriage. The main exercise, if marriage is a arranged marriage, the parents and guardian and other relationship must find out that they should not be cheating, they should not be concealment. They must explore that husband, this male partner or female partner is a bachelor and not having earlier relationship, earlier wife existing. So then, if that is there, then obviously they will be in trouble. Relationship afterwards, if there is a concealment of facts, then there would be a matrimonial disputes. So then I here today I have delved upon section 17 of Hindu Marriage Act, and simultaneously I have dealt with section 494 and 495 of IPC, because it is related to criminal liability is available. Whosoever is entered into second marriage, it is a this is a it is a gender neutral section, section 17. But exception is here. Exception is here with regard to Muslim solemnization of a Muslim male second marriage. He can enter into Ayabadali. I hear again a retreat that he can enter into four marriages. So he, he cannot be held liable for bigamy. Now, there is in this section of this judgment a suggestion, a direction, a recommendation has been made by Supreme Court of India regarding uniform civil code. Civil code, which is now the Government of India Law Commission, as the matter is now pending before this Parliament, and I think it is before the concerned committee. The explore, because they are saying that it is a this sections are section 494 and 494 is a is you may say it is discriminatory. If there were a uniform civil code, civil code, the Muslim male can also be prohibited, restricted from solemnized second marriage. And if he violates that, then he can be held liable under these two sections, 494 and 495 of Indian Penal Code. Or simultaneously, it is discriminatory towards the female, because female, the wife cannot cannot go back second marriage. If a female having earlier in marriage bondage cannot solemnize second. This is what related to this Christian law is codified, or Hindus under Hindu law. Definition of Hindu, the Buddhas are also included. I have already talked about this. Jains are also included in this definition of Sikhs are also included. They are also Hindu as per our Hindu Marriage Act and Hindu law. Now, Parsis, under Parsis, the fact bigamy is not recognized, not legalized. If they also enter into relationship with the second wife, they solemnize second marriage, then they also be held liable under section 494 and 495 of Indian Penal Code. This is today. Now, I think one more section is important related to this marriages, and it is available under chapter 20 of Indian Penal Code. And obviously, this is related to adultery. Then I will talk about that, which is available, the section available in 497 of Indian Code. Supreme Court has a judgment which has declared this section to some extent. It has made decriminalized. Then we will talk about in the next episode regarding section 497 of Indian Penal Code, how it was earlier. It talks about criminalization, and after this coming of the Supreme Court judgment, now it is decriminalized, this section. What how this is, I will talk in the next episode. इस टॉपिक है 497 करेंगे इंडियन पिनल कोड के सेक्शन पे, जो ऑफेंस पे। तो ये ऑफेंस है, कब इसको डिक्रिमिनलाइज किया, पहले क्या था, कैसे इसमें जो चेंजेस आई है जो सुप्रीम कोर्ट जजमेंट की वजह से। तो इस पर हम नेक्स्ट एपिसोड में बात करेंगे। तो मुझे इजाज़त दीजिए, और यही मेरी रिक्वेस्ट है कि इस चैनल को आप सब्सक्राइब करो, लाइक करो। अगर आपको अच्छा लगता है तो इसको आगे शेयर करो। थैंक यू वेरी मच।